I see, Mr. Kuchek, that you are just alone this morning, so you're going to have your 15 minutes. And you know our system now that we have the monitor over here that you can keep track of your time as well. And hopefully I can remember to do it the right way so that we'll both be on the same page. But at any rate, you also know the rules that we're getting videotaped, so it will be on YouTube. So you just have to keep your voice up and stand behind the podium, and obviously we also try to tell everybody now, and we just say it on every case so that we don't forget anything, and that is if it's victims or children in any shape, manner, or form, we want to make sure we use initials or just refer to them as the victim or something like that. Okay?
Yes, Your Honor.
All right, you got your 15 minutes. You may proceed.
Good morning, Your Honors. May it please the court, I am Richard Kudichief, and I am court-appointed counsel for Michael Florio. I'm here today for a reason, because I think Michael's matter resulted in an injustice. So you're probably saying, or maybe someone is thinking here, why are you here, Richard? Come on. Foster. Kalish. Well, this court can sit and say, look, we're not going to talk about sentencing. We rely on the trial court, but can we ever challenge a sentence? And the answer is yes. 2953.08G2 provides for that. So I'm here to stand up for Michael Florio. I may be the only person he has, although his family has come out for support for him. But the factual basis here has to do with Michael's life after he got involved in a motorcycle accident, and his life kind of turned south, if you will. He was living with a friend. That friend got evicted, so Michael moved out. He really had no place to live at that time. So it was winter, it was in the freezing cold of March. So for whatever, Michael decides to go back and squat. His neighbor, whom he knew for quite a while that they interacted, the victim, for whatever reasons, okay, he's a good citizen, he calls the police. So the police come, they arrest Michael, it's a criminal trespass. He goes to court, it's not disposed of. He's released on bond, and then, he's still having a problem finding a stable place to lay his head. He goes back once again. Again, someone calls the landlord, right or wrong, and here Michael gets in trouble once again. Michael goes to court, he writes then the victim a letter and says, why is this going on? Why are you doing this? We used to be good friends, neighbors. He demonstrated his displeasure, said some of his reasons behind going and squatting. But notwithstanding all of that, so that's a March event. Then we supposedly have a couple months later an event in social media where Michael is claimed to have said some things. So now we have March, now we have May, now we get into July. So the course of conduct the trial court is looking at is interspiced. It's really not consecutive, but there's some interactions that go on. Michael is said to have vandalized a car of the victim. And then Michael gets a vibe that the victim is going to now be out to get him. Michael says, somebody tells Michael the victim is going to shoot him. And Michael knows the victim has a gun, a concealed weapon permit. So he goes and talks to the victim and says, look, what's going on? Why is all this happening? My client claims that the victim spit on him, that there was conversation, and then the victim reached for his gun. A fight ensues, Michael pops him. So we have a simple assault again, and not to minimize the events, but the claim is a continued course of conduct by the the defendant, by my client, Your Honors, let's look at, and I'm not here to disparage the victim, okay? Let's take a look at a continued course of conduct. So when we look at sentencing, we also look at, is there any behavior of the victim that may play into the event or play into the circumstances that is reviewed. And so I'm not faulting the victim, while in the same breath the victim did play some part in providing this. So when the fight ensues, whatever happens, they're on the ground. When the police come, it is determined the victim does have a gun on him. So the victim makes all these claims, while in the same breath, you're wondering, if the victim has a gun, how can this all go down as such? So what, notwithstanding, the other component that can be found in the record, Your Honors, is that, and this is the right of the victim, okay? It's not typical, it's atypical of a victim, in my humble 40-year experience, for the victim to show up at every single court appearance. Now, that's okay, and you know, I'm right with the Constitution, and that right is very important, but it's not typical. So in the one event, it's claimed that when Michael goes to court in Stowe, he yells something out to the victim, whom the victim claims says, "You're dead." Michael categorically denies that. Notwithstanding, for that remark, my client is charged with intimidation of a witness.
Counsel, let me stop you. I'm a little confused as to how all this is in the record. Did that come up at sentencing? All of these? Did you guys argue about all this at sentencing?
Yes, Your Honor, thank you. There is 9 months of detention in this case. There are multiple hearings. The victim is at many of the hearings, but the state makes these statements to the judge on the record relative to this claimed behavior.
Okay.
And
my understanding from the state's brief was that the bailiff actually overheard the comment or the threat, whatever you want to call it, that was made at the Stowe Muni Quarter.
the bailiff claims that he did overhear it. However, there's no evidence to corroborate the exact remarks that were made, or how the bailiff, or where the bailiff. So the claim is, it is said, but in the PSR, we're talking about what Michael's side of the story is. Anyways, Michael has a conversation with the detective, and that's where he does tell his side of the story. Again, the frustrated victim continues, in my client's estimation, to keep calling the police. And it ends up with all this. Now, let's take a look at the individual here, Michael. Michael, up until this point, comes to the court with virtually no history. So he has a disorderly conduct, and then he has the criminal trespass, which, again, is part of this ongoing course of conduct.
How old is he?
He is 60 years old at this time, Your Honor. At the time, he was 67, 68. So, lived in Cuyahoga Falls, had a family, hardworking. He was a guy that worked all of his life until these things started falling apart. So, he comes in with virtually no history. So, I'm thinking, all right, we're going to settle this case. Michael's never been contrite or cavalier about this. He comes in, accepts responsibility. Here I am, I'll evaluate the situation. Nothing history, served 9 months in jail, accepted responsibility. He pleads to attempted intimidation, attempted retaliation, and menacing by stalking. 3 F4s, which typically are not going to send anyone to prison. So, when we get to the sentencing, the result, as you clearly see, is 3.5 years. So we have nothing whatsoever that supports the consecutive sentences leading to 3.5 years, and that's why I'm here today. So let's take a look at how the court, the overriding sentencing purposes are regardless of Foster, Kalish, anybody else, the United States Supreme Court. The sentencing precepts here and across the nation are the same. protect the public, punish the offender, promote effective rehabilitation. But with minimum sanctions. So yes, we look to deterrence. So if we have protection in society, we have one interaction between two people. It's not something that's likely to affect society as a whole. Punishment of the offender, 3.5 years. Promote effective rehabilitation. He was in custody for 9 months. So let's take a look at the understanding that the court has in this matter, and then how, when you look at the record, Your Honors, there is no foundation in this record to provide for consecutive sentences. So number one, consecutive sentences are necessary to protect the public or punish the offender. Is 3.5 years necessary? Answer, overly. So 18 months, because we have a presumption, the statute has a presumption in favor of concurrent sentencing, 2929.41a. It says right there in the law book. So the number two thing, that consecutive sentences are not disproportionate to the seriousness of the offender's conduct. The serious nature, this is not the worst form of behavior on any of the pleas of the 3 counts that my client entered into. Furthermore, the court...
Just out of curiosity, and I can't recall from reading the brief, was there a PSI and is that part of the record?
I'm sorry?
Was there a pre-sentence investigation and is that part of the record?
Yes, Your Honor.
Yes and yes.
Yes, there is a PSI.
Sorry to interrupt you, go
And
ahead.
yes, it is part of the record. So, the court goes on to say at least 2 multiple offenses were committed as part of one or more course of conduct. Again, if you look at the course of conduct, it is not a course of conduct. Moving into, squatting into an apartment, okay? Then we have this alleged claim of retaliation in court, not related. Then we move into the vandalism, and then we move into the fight. These are isolated events. Number 4, the harm caused by 2 or more of the multiple offenses so committed was so great or unusual. That is not found in this record. This behavior of my client is not so great or so unusual. So those findings, you need to look at clearly and convincingly to overturn a sentence. That's the standard. But also, what does the court say about that standard? It's just a little bit more than the preponderance of the evidence. It's not proof beyond a reasonable doubt. So the court, in discussing that, is clear when it sets the standard of review here. Also, if you take a look at Dr. Wood makes certain recommendations that are very sound in dispositional analysis. Dr. Wood does not say this man needs to be subject to punishment and incarceration. So I implore to this court and request you to review the foundational basis, which is basically boilerplate language that the court lays out, as to consecutive sentences. This court, you can deal with consecutive sentences. You should deal with consecutive sentences. And the reason I believe that's so important, when we're getting away in the world with minimum mandatory sentences, first of all, and discretionary sentencing by the court, we also need to have, it's not an abusive standard, I understand that, but we still have to have some confines when it gets to maximum sentences or consecutive sentences. And that's, Your Honors, why I believe this case is so important. This court has an ideal ability to make rulings on how consecutive sentences on the record formulated by the court is supposed to happen. And in this case, I do not believe that Michael was appropriately sentenced. I think his sentence was overboard, and that consecutive sentences in this case, pursuant to law, were improper and abusive discretion, and clearly and convincingly against the precepts of statutes and case law relative to sentencing.
Dr. Wood's report, is that in the record as well?
That would be in the aid and sentencing. Honestly, Your Honor,
Neither is
I may be,
so we'll
I may be,
check
it may not be in there. I think it's maybe part of the PSR, but forgive me, I cannot answer that with certainty.
All right, well, if it is, we'll see it. If it's not, we won't.
This is true. Well, if there are no further questions, that ends my presentation. I want to thank the court for listening on behalf of Michael Florio.
Thank you, counsel. And you know the procedure, we will take the matter under advisement and issue a written opinion that will be sent to you as well as to the state. And you can also look on our website for the electronic release. Thank you.
Yes, Your Honor. Thank you.
Have a good